Now we have a contract, but what does it mean? And what have the parties done? Welcome to the Contracts 2 review, and I'm Professor Seth C. Orenberg. Today we're going to step through some examples and illustrations with a little story I call It's a Dog's Life to help show you how we're going to interpret contracts and how we're going to understand whether parties performed under them, with a brief discussion of what damages might result if the parties haven't fully performed. This is an educational video, and it's going to give you an overview of contract law that we spent an entire semester discussing in detail. So this short video is going to make complicated ideas seem simple. A lot of this is in fact an oversimplification, but I'm providing this video to give you this overview so you understand generally how to perform the contract analysis required of you at the end of this course. Also, I'll point out that all the illustrations are fabricated for educational purposes. With that said, let's dive in. I articulate 12 steps you can apply to determine what a contract means, whether parties have performed under it, and whether damages may be owed. You might follow your own steps, but these help me understand and remember what I need to do in order to answer questions about whether or not contract interpretation and performance has been fulfilled. I start by confirming that there is a binding agreement, because we only analyze contracts that actually exist. Then we want to focus in on that agreement and determine what parts of it are really relevant. Contracts can be very long, and we don't want to spend too much time reading everything that's not important in them. What is really important is what is not clear. This is where courts come in and have to resolve ambiguities in agreements. So we have to find what could be determined to be ambiguous and is relevant for the parties at hand. And then we try to resolve those ambiguities, both by using the canons of construction and looking at the intrinsic information within the four corners of the document, and sometimes admitting extrinsic information and looking at facts and circumstances, course of performance, course of dealing, uses of trade, and other matters that can help us understand the circumstances in which the contract was formed. Sometimes we can't resolve these ambiguities, and so we wave a magic wand and say Contra Proferentem, which means construing the contract against its drafter. Sometimes parties will claim that matters related to the contract were not actually written down, and they want to introduce evidence that they had these additional conversations or agreements. The parole evidence rule will bar certain types of evidence from coming in when we have a final or exclusive writing. Additional terms might come in because they're implied from circumstances, and one of those is the implied term of good faith and fair dealing. Now that we understand what the contract consists of, we need to determine whether or not its terms are promises or conditions. When a condition occurs, it creates a duty of the other person's performance, whereas independent promises have to be performed whether or not the other promise is performed. So we move into the performance category as we start to determine whether or not conditions have been satisfied or whether they're in fact mutual promises. And if things haven't been satisfied, we're in a situation called breach. Breach is any failure in performance, and breach always can lead to damages, but not all breach is material. So we first determine if breach is material and then see if it's partial or total, and also we'll look at whether or not we have a breach that occurs because of a repudiation. Sometimes a party doesn't perform, but that failure to perform is excused, and so we'll discuss the doctrine of excuse briefly before concluding with a brief discussion of damages. So let's get started. And step one is to make sure that we actually have a binding agreement. Now, we studied this last semester in Contracts 1, but we'll briefly look at the contract to make sure that we have its essential elements of offer and acceptance, which together constitute mutual assent, consideration, no obvious defenses to formation, such as mistake, fraud, misrepresentation, and the statute of frauds, where we have a signed writing required, is either satisfied or not required here. So in our first illustration, let's take a look at the contract. Chandler enters into a written agreement with Yankee, Doodle, and Poodles to purchase a puppy. So to start our analysis, let's just take a quick look at the contract to briefly understand what it means. I'm going to go ahead and show the next slides with the contract on them for you to read at your convenience. All right, that was a lot to read, and it might not be necessary to cover in detail a full analysis of every term in that contract. So we actually want to narrow our focus by looking next at the fact pattern presented to see what is really relevant here. We're going to be turning back to that contract, so it's good that we're familiar with it and we have a general idea of its scope and what it covers. But in order to really understand what we need to look at in the contract, we need to understand what the parties are disputing about. So illustration 2, the contract said the puppies will be delivered in good health. And it contained other terms such as sex of the dog, health warranty, buyer's responsibility. And we need to look at what is really important here. So we have to understand what is the controversy. So the controversy presented in illustration 2 is that when Chandler gets his puppy and takes him to the vet, he discovers the puppy has worms. So the court will probably focus on what good health means here, as well as the terms related to conditions that can go away on their own or that are common, etc., etc. So let's look back at the contract for a minute and focus in on those provisions. We're going to turn back to that fourth paragraph on the slide here and says the buyer agrees to have the dog examined by a vet. If the vet does not give the dog a clean bill of health, notify the seller. Seller reserves the right to have the dog re-examined. So what conditions are covered? Any condition that is minor, correctable, or a breed-related minor condition is not covered, and no condition which could go away or is considered to be a condition which a puppy will likely grow out of is covered. So under the contract here, we need to understand whether or not worms is a condition that would be covered or not covered. And so thinking about the analysis a bit here, we need to better understand, is worms a minor condition? It happens to be a correctable condition. And so certain types of worms, like intestinal parasites, are fairly minor and correctable. Other ones, like heartworms, can be more serious. So we might need a little more information. And if you're writing this in, for example, an essay answer for a law school exam, discuss a little bit about how the type of the worms or the type of the condition needs to either fit into this paragraph or not. And so we're looking to interpret what this paragraph means to see if the actual condition presented falls within it. In specific, we're going to try to understand if the contract here has some ambiguity around a core term. If the contract is unambiguous, for example, the contract could have said intestinal parasites, i.e. worms, are not covered. It didn't say that, so we have some ambiguity here as to what this good health means. We have two kinds of ambiguity to look for. Ambiguities that are patent, which means that when we look at the contract, we can tell that it's not clear. That's probably not the case here. We look at this contract and say, okay, good health, normal conditions, I understand what that means. The parties probably agreed on that. But we may have a latent ambiguity because the parties could have had different opinions as to whether or not worms or a particular type of worms, intestinal parasite or heartworm or what have you, either meets the covered definition or doesn't. So we might have this misunderstanding between the parties as to whether or not this is a covered condition, and it's up to the judge to determine how this ambiguity can be resolved. So again, here the good health condition might be ambiguous, and do we know from the four corners of the contract what this means in terms of an 8-week-old puppy? Well, actually, it's not entirely clear. It didn't say everything that it needed in there. So there might be some patent ambiguity because when we think about it, it didn't list every possible condition. And this might be a latent ambiguity that the parties discovered as a result of the circumstances that came up. Worms didn't really clearly fall into one of the two categories. So we have to ask, can a puppy have worms but be in good health? Is this one of those conditions that's meant to trigger? What did the parties intend? Let's try to resolve that ambiguity within its four corners. So we're going to try to give meaning to the contract based on its four corners using the 13 canons of construction. Usually, if courts can determine the meaning of a contract based on the canons, they'll stop there, although sometimes courts will also admit extrinsic evidence, and we'll discuss that in step 5. So let's look at what are those 13 canons of construction. Canon 1, we're going to start with the dictionary meaning, and this is really a baseline. So when we're determining what a word means, we're going to pull out a dictionary and see what it generally means. That's true, except with words that have technical meaning. So Canon 2, if the parties are in the same technical field, and that's important, they both have to be in the same technical field, meaning they both had to understand the term and its technical meaning, then we're going to actually apply the technical meaning as understood in that field. Canon 3, sometimes we have multiple writings that form a single agreement. This is common, for example, in a merger. It's not in the case that we have in front of us here, but if we had a merger agreement, a shareholders agreement, an escrow agreement, and they all form part of one transaction, we would look at all of those documents to have meaning as a whole. Canon 4, we're going to try to give force to every term in a contract. We assume that parties didn't write something down unless they meant it to be enforced, so we try to give meaning to every term. For example, Let's take an example of a contract that says vessel to be loaded in turn and also says vessel to be loaded promptly. So on the one hand, these could be contradictory or one could have no meaning, right? What would be the meaning of loaded promptly if we've already said it's going to be loaded in turn? So instead of saying that one of these phrases doesn't have meaning, we give meaning to every term by saying this means that the vessel should be loaded promptly when it is its turn. Canon 5, we're going to give preference to specific things over general things because we're assuming the parties paid more attention to the detailed provisions they took the time and trouble to write, so we give greater weight to specific language. Canon 6, interpret words consistently, is essentially saying that the same words mean the same thing when they're used in one set of writings or writing a contract or an agreement. And the flip side of this is that different words mean different things. And so we try to give the same meaning to the same word when it appears in a single agreement. 7, the words need to be interpreted in context. So for example, let's look at a list and understand it as a category. Imagine a contract that says contract for flood insurance, covers damage from flood, surface water, waves, tidal waves, overflow of streams or other bodies of water, or spray from any of the following, whether driven by wind or not. In context, this list seems to show a list of inundation from natural sources, and so we might think that damage from a broken water main is not meant to be a covered condition because of the context of these words. Canon 8 is a little less intuitive, so let's talk about it for a minute. Specific words can limit general lists. When parties add a general term after a list of particular items, they're probably thinking of them as a single category, and so that general term will derive its meaning from the specific terms that precede them. So for example, we're going to convey animals. And so here we have a list and say horses, cattle, sheep, pigs, goats, or any other farm animal. So you might think that the general language of any other farm animal includes things like chickens, but you could make the argument, and Canon 8 would uphold the argument, that the phrase horses, cattle, sheep, pigs, and goats that precedes those specific terms that precede the general list diminish the seeming breadth of it. The previous list of specific animals is four-legged, hoofed mammals typically found on farms and does not include chickens. And so chickens is probably excluded from this general list. Canon 9, if the parties took the time to write something down as opposed to boilerplate terms that you find in all contracts, we give preference to the terms that the parties actually wrote down. And sometimes on a contract you'll find that before signing the parties actually X something out and hand wrote something in. Courts give special weight to that. Canon 10, expression of one implies exclusion of the other. Parties usually think in categories, and so if they omit something from the category, we assume that the omission is conscious and intentional. This is the flip side of the canon that says we have to give force to every term. We're actually giving force to every omission, too. Canon 11 is to avoid illegality, so if we can understand the contract in a way that it's enforceable and not illegal, we'll interpret it that way. For example, if there's two ways to interpret a loan agreement, one of which has the amount of interest charged being usurious and therefore illegal, and another interpretation of how we calculate interest making it legal, we're going to prefer the legal version so that we can uphold the contract. Canon 12, we're going to assume that the parties are using grammar properly and ask them to understand the contract in terms of its grammatical construction. And so cases have been won or lost over and versus or. And one of those kind of unusual rules that I'll mention specifically is Canon 13, the last antecedent rule, which is a grammatical construction that says the clause closest to the phrase being modified is the one that is only the one that's modified by it. So let me give you a specific example. Let's have a licensing. So you need to get a license for driving trucks, tractor trailers, boats, and cars over 2,000 pounds. So here, that last antecedent, that phrase, that clause, over 2,000 pounds, is closest to and only modifies cars, and not the other items in the list like trucks and trailers. Let's take a look at how this might help us understand the contract at hand here. Well, the dictionary meaning of good isn't very helpful, nor is our basic dictionary definition of health. These seem to be somewhat technical meanings that we might have to do a little bit of digging to understand what is known in this industry. Now, the term good does appear elsewhere in the contract. The buyer agrees to take good care of the dog. Does that help us a little bit? And the seller certifies that the dog has been in good health and has been immunized in worms. So now we have this concept of worms coming out elsewhere in the contract. So we're trying to understand the contract consistently. It seems that good health does involve not having worms, although maybe being wormed is not the same as not having the condition. So there's some arguments on both sides, and so the next step is, in your writing of this essay, sort of discuss how the contract itself could lend itself to certain types of meaning. I think the conclusion here is that we have to go beyond the four corners of the contract to really understand what the parties intended, because even applying the canons of construction does not necessarily tell us what this contract meant in terms of whether or not worms was a covered condition. Most judges will allow some preliminary consideration of credible evidence because you can't determine if there is a latent ambiguity without understanding the facts and circumstances around the contract. So the court might look at evidence of preliminary negotiations or the course of performance, which means what the parties have done to perform this contract, the course of dealing, what the parties have done with each other in prior contracts, or trade usage, not involving these parties, but how do these contracts generally operate. What type of evidence might our parties here introduce? Well, Chandler told YDP before signing that he wanted a dog with a clean bill of health from a reputable breeder, and YDP assured him that our dogs are properly cared for and warranted against health defects. That evidence might come in, at least as a preliminary level, but I'm not sure if it helps us understand whether worms is covered. This is a one-time transaction, so there's no course of performance. The parties haven't dealt before, so there's no course of dealing. Now, Chandler has never purchased a puppy before, so he's not aware of trade customs, and so we're going to be less likely to admit evidence of trade custom when only one party is aware of them. But the court might hear evidence, at least on a preliminary basis, that worms are not generally considered a major health risk in the dog breeder industry, and might hear some testimony that says that this is very common, it is a treatable condition, it is something that's likely to go away, especially if they're intestinal. If the court simply can't interpret the contract one way or another based on intrinsic and extrinsic evidence, it will wave its magic wand and say Contra Proferentem and construe the contract against the drafter. I'd put this outside of our canons of construction because it's not really a canon of construction that tells us what the parties meant. This is a policy choice. It's a policy choice that favors the party with less bargaining power. So when a party has less bargaining power and didn't have the right to change or modify the agreement, the other party was able to provide this contract of adhesion or was otherwise more sophisticated, we're more likely to construe the meaning of the contract in favor of the less powerful party. So here, YDP wrote the contract, but it turns out it's just a form that they downloaded from the internet. And this is a dog breeder, not a particularly sophisticated party. And on the other hand, we have a contract attorney, a professor of contracts law. So the court will probably not wave the magic wand and construe the contract in favor of Chandler this time around, although there are some cases you can imagine where one party is so much more powerful than the other that the contract is written in a very confusing way and cannot be disambiguated, and the court will rule in favor of the less powerful party. By step 7, we have a pretty good idea of what the contract says and what it means, but the parties might claim that there are things that are not in the contract that they also want to admit into evidence. If the parties allege the contract doesn't contain all the terms that they agreed on, when will courts allow it? That depends on whether the contract is a final or a complete and exclusive integration, because the parole evidence rule bars evidence of prior negotiations that contradict final written terms, and it bars evidence of prior negotiations that add terms that are within the scope of a complete and exclusive integration. So in this first step, we're going to try to determine what is the nature of this contract. Is it final or complete and exclusive? And if so, what kind of evidence can come in? Let's look back to the part of the contract that has what we might call a merger clause or an integration clause. This isn't the best written integration clause that I've ever seen, but it does say that this is the entire agreement between the parties. What does it mean for this to be the entire agreement? Does that mean that this is the complete and exclusive agreement? Does it mean that these terms are final? Note that this printed out was only 2 pages long, so it's not a very robust agreement. And this merger clause is not completely clear, and these parties are not especially sophisticated. So courts would probably find this to mean that this is a final agreement, but they may not find this is a complete and exclusive agreement. Although the idea of this being the entire agreement, if that's upheld and that's understood by the parties, could show that this is a complete and exclusive agreement. So what would happen if Chandler claimed to the court that before signing the contract, YDP also promised to provide the puppy along with a scent object, a collar, a leash, and his favorite toy? The contract doesn't address accessories that are included with the sale of the puppy. And it does have this, maybe it has an integration clause, maybe that's not an integration clause, not entirely clear. But at most, the writing is probably final. It could maybe be complete and exclusive. So how would this impact our analysis? Well, If the agreement is final, then we would not admit evidence of terms that are inconsistent. And since nothing in this contract talks about sale of accessories, it would not be inconsistent to admit evidence that they had a conversation about the sent object, collar, leash, and toy. On the other hand, it seems that if this is a complete and exclusive agreement, those terms are part of this transaction and so should not be admitted because they are so closely related. Even if, however, the contract is complete and exclusive, Chandler could still argue that the agreement to get the sent object, collar, leash, and favorite toy are collateral and are separate from conveyance of the puppy, although he'll probably lose that argument because he's not arguing there's any extra compensation owed for them, and it does seem like the puppy's toy is part of the transaction for the puppy. Next, we'll consider whether there are any terms that the parties didn't write down, maybe didn't discuss, not parole evidence then, but might also be implied based on the circumstances under which the contract was formed. Keep in mind that parties don't write down everything they mean. Sometimes things are so obvious they don't bother to write them down. Other times they're difficult to agree on. And depending on the circumstances under which the contract was formed, they might be important to understand the intention of the parties. Always, the court is trying to get into the minds of the parties and to affect their intent that they made when they contracted. One of these duties is the duty of good faith that's always implied in contracts. So every contract will have an implication that the parties will perform the contract with each other in good faith. The parties cannot know in advance all the possible bad faith acts the other will take. In fact, it would be pretty bad for the contracting process if they had to sit down and flush out all the bad things they could potentially do to each other and write them down. So courts imply a prohibition against these limitless bad acts by having a duty of good faith implied in contracts. How does that apply here? Let's look at some evidence that helps us get into the mindset of the parties. So in their initial conversation, Chandler told YDP that he's allergic to most dogs, and he wants a dog he's not going to be allergic to. YDP responded that golden doodles are great because for people with allergies, they don't shed, especially the ones with curly coats. And the website says, F1B, when you breed an F1 golden doodle, which is a golden retriever, and a poodle, back to a poodle, so now we have 3/4 poodle, it eliminates the little bit of shedding that you get with an F1 and makes them less likely to trigger an allergic reaction. Now, let's say that when Chandler picked up the puppy, it actually had straight hair. And he met the parents, and one of the parents was a full golden retriever, so he ended up getting an F1, not an F1B. Flip back to your agreement, but the agreement's silent on this. It said golden doodle. It didn't say anything about F1 golden doodle, F1B golden doodle, breed of the parents. So what are we going to do here where the contract is silent? There was no express term that he wants to evidence to bring it in, but there was this conversation that shows the intention and the mindset of the parties. The court might imply from these circumstances that the entire purpose Chandler had in getting into this contract was to get a hypoallergenic dog. And if, in fact, the dog that they provided to him is not hypoallergenic because it was bred differently, it had different hair, this might be a breach of the agreement in favor of Chandler because he did not get what he bargained for, even though it wasn't a term that was written expressly in the contract, because it was something that he clearly expressed and thought was implied in the contract. Courts can take two different approaches to determine what the parties intended. One is a subjective approach. What did Chandler and YDP actually intend in this transaction? Another approach is a more objective approach about looking at what a reasonable person in a similar situation would expect. Here, since Chandler and YDP are available, we could probably hear testimony from them to get to their subjective intentions. If they weren't available, or for some reason it was more helpful if there was some common case law about this, we might look to general case law or general principles to get to a reasonable person standard here. Now that we know what's in the contract, we have to know what those things are, how they operate. There's a different legal mechanic for things called conditions as opposed to promises. Terms can be either promises or conditions. Independent promises have to be performed whether or not the other party performs their promises, but one party's performance can be conditioned on the performance of the other. One example of a condition can be found in a contract for insurance. The contract might say, client must give notice to insurer within 10 days of a fire, and then insurer must make the payment. Courts will probably construe the notice to the insurer as a condition precedent. The insurer is not obligated to make the payment if the person, the client, does not give the notice within 10 days. This is a type of express condition, and the most clear express conditions are ones in the contract that are written down and say, it shall be a condition precedent to buyer's obligations that. Conditions precedent are ones that trigger a duty, and that duty does not exist until the condition precedent occurs, whereas conditions subsequent terminate a duty, and the duty will exist until the condition occurs. Conditions can be express or implied. The most common example of an implied condition is where you have a contract with a contractor to build something for you, and you're supposed to pay him and he's supposed to build something. Let's say you hire someone to build a roof and you say you're going to pay them $10,000. You probably would not be too surprised to find the law generally holds that your promise to pay is conditioned on their building of the roof, even if this wasn't expressed. And so if the person never builds the roof, you don't have to pay them. Of course, the parties can write things differently. You might have a schedule of payments that says on the first day that he shows up on the job, you pay $1,000. When he brings materials, you pay another $5,000. And when he's finished, you pay the final $4,000. But if there's no statement about this, it can often be an implied condition that the performance of the construction has to occur before the payment has to come in. If, counterfactually, the YDP contract said it shall be a condition precedent to YDP's obligation to transfer the puppy to the buyer's home that the buyer has puppy-proofed the home and has all the necessary supplies, including a crate and at least 1 week's supply of puppy chow. Well, if that was the case and Chandler showed up to take delivery, YDP could say to him, "Have you done all these things?" And if he replied, "My house is all safe, but I'm going to pick up the puppy food on the way home," Chandler has not strictly complied with an express condition. Generally, express conditions require strict compliance, and so here, since Chandler is not strictly performed, YDP does not have to deliver the puppy. However, YDP can't refuse to perform for a bad faith reason. For example, if they are refusing to perform in this case because they know someone is coming in an hour to purchase the puppy for twice as much, and they're trying to get out of the contract, and they're using this clause for that purpose, that's one thing. If, on the other hand, this was a clause that was written in to protect the puppy's safety and the integrity of their business, and by not having prepared, Chandler has demonstrated that he's not capable or likely to take care of the puppy properly. In that case, they're welcome to stand on their rights and refuse to make the transaction. All right, now we know what the contract says. We know what the implied terms are, the express terms are. We know where we have conditions, whether they're express or implied, and whether or not we have evidence that comes in from parole evidence. But now we have to diverge the analysis a little bit because now it's time for the parties to perform, and different things can happen. We don't necessarily take one step if the parties and the actions that we see presented to us lead us in a different direction. So when the parties completely perform without event, by the time the performance is due, we're not going to continue any analysis. There really isn't grounds for a lawsuit. So we're looking for some kind of breach, some reason why performance wasn't done. If the performance is not done at the time that it should have been done, when performance was due, the analysis we do is an analysis for breach. If, on the other hand, or potentially in addition, the party in advance said they were not going to perform or gave reasonable doubt to the other party that they would not perform, we perform an analysis for repudiation. And so in step 10, we're going to look at both of those. Let's start with the potential breach analysis in step 10. So in what I'm calling step 10.1.1, we're going to look at the restatement 5 factors to see if we have a material breach versus substantial performance. Keep in mind that any breach can result in damages. Even if there's substantial performance, still that small amount of breach can constitute grounds for damages. But now we're evaluating whether or not there has been a material breach, because a material breach can extinguish the other party's obligation to perform. So we're going to look at the 5 factors, which are A, the extent to which the injured party will be deprived of the benefit from which he reasonably expected. B, the extent to which the injured party can be adequately compensated for the part of the benefit of which he was deprived. C, the extent to which the party failing to perform or to offer to perform will suffer forfeiture. D, the likelihood that the failing party to perform or offer to perform will cure the failure, taking account of all the circumstances, including any reasonable assurances. And E, the extent to which the behavior of the party failing to perform or to offer to perform comports to the standards of good faith and fair dealing. Let's apply those 5 factors here. So YDP has provided to Chandler a puppy who is an F1 Golden Doodle with straight hair. Chandler expected an F1B Golden Doodle with curly hair. Is this a material failure or is this substantial performance? So, A, the extent of deprivation of benefit. Chandler got a puppy, but he really expected a hypoallergenic puppy, and this puppy is less likely to be hypoallergenic. So Chandler was somewhat deprived of the benefit that he expected. In fact, Depending on how the contract is interpreted, the entire purpose might have been to have a hypoallergenic dog, and if this dog is not hypoallergenic, then he might be totally deprived of the benefit. B. Adequacy of compensation for the injury. Well, what is the value of a hypoallergenic puppy versus a non-hypoallergenic puppy? It can be hard to say, but in this case, there are probably other puppies for sale, and we'll find that we might be able to conduct a study and say, well, F1B Golden Doodles sell for $1,200 and F1 Golden Doodles sell for $800, and so he was deprived of $400 worth of benefit in that case. Will there be any forfeiture? Well, YDP can probably sell this puppy to someone else for its full price, so it's unlikely they'll suffer forfeiture here if we decide that the contract has been breached. D. Likelihood of cure. YDP says Chandler can pick a curly puppy from the next litter, showing a high likelihood of cure. And D. Extent of bad faith. Well, let's assume YDP says they didn't realize Chandler preferred the curly puppy, although they did sell the last one to someone else for more money. So maybe we have some evidence there of bad faith, that they knew that Chandler wanted this type of puppy, but they sold it to someone else because they got more money for it. Next step, we have to distinguish whether or not we have a partial breach or a total breach. This is all if we have a material breach. So we actually start with the five-factor test for material breach, as we just covered, and then we add to that whether or not the delay further injures the injured party, and to the extent to which the agreement was made time of the essence. Because the difference between partial breach and total breach is total breach gives the party who is harmed the right to cancel the contract and go elsewhere, whereas under partial breach there's a cure period. So we're concerned here about time, delay, and injury from that time delay. Adding these factors here, we determined earlier that YDP's failure is probably material because Chandler did not get the benefit he expected. YDP won't suffer any forfeiture, and they might have acted in bad faith, although they might actually cure. Since cure is reasonably likely, and since Chandler does not seem to be substantially harmed by waiting, this is probably a partial breach and not a total breach, so we need to give a cure period here. Waiting for YDP to cure will not prevent Chandler from getting another puppy from another breeder if YDP does not cure. If this was the last puppy in the universe, then that might be a different story, but puppies are being bred frequently, and the contract here does not demonstrate that time is of the essence. This is just a pet that Chandler wants to enjoy, and his enjoyment is deprived a bit for it, but it's not like he needs this dog for a service mission or a type of purpose like that. That time is of the essence. Now, in addition to, or instead of, a breach at the time performance was due, if performance is not yet due, a party can still breach by repudiating the contract by language sufficiently positive to mean that they cannot or will not perform. Note that the mere expression of doubt or of to ability as to perform is not sufficient. The Restatement Section 250 defines repudiation as a statement indicating that the obligor will commit a breach or a voluntary affirmative act which renders the obligor unable or apparently unable to perform. So, for example, the party might say, I sold the last puppy and the date for performance is tomorrow, but this can constitute repudiation because it's a voluntary act rendering them unable to perform. You can't transfer a puppy that's already been transferred. The repudiation itself may cause harm and allow the doubting party to suspend performance until receiving assurances, similar to the cure period we described in the partial breach scenario. So let's look at an illustration here. We didn't conclusively determine whether worms would be a type of condition which would be a health condition sufficient to violate the contract, but let's assume we have a more serious condition of a heart murmur. Now, the breeder says the heart murmur will usually resolve within 4 months, but independently, Chandler talks to a vet who determines this is a fairly serious medical condition. It won't necessarily resolve and does prevent the puppy from having a clean bill of health. So YDP, by saying the puppy has a heart murmur and there's nothing we can do about it, has probably repudiated their promise to provide a puppy with a clean bill of health. So what can Chandler do? 1, he can demand assurances that YDP will provide a healthy puppy and wait for YDP to perform. 2, he can sue for any harm caused by the repudiation. And 3, he can stop making payments required under this contract. If YDP does not make those assurances, Chandler can go ahead and cancel the contract. Sometimes a failure to perform is excused. Performance can be excused where it's impossible, impractical, or where the purpose of the contract is frustrated. Generally, this requires the occurrence of a contingency, the non-occurrence of which was a basic assumption on which the contract was made, not the party's fault, which may include death or incapacity of a person necessary performance, destruction of a thing necessary performance, prohibition or prevention by law. All right, time for illustration 11, a sad one. But keep in mind that these are all made up, and this is a happy puppy who is still around. So in illustration 11, let's assume that the puppy with the heart murmur begins to develop some real symptoms from it. Lethargy, blue gums. YDP takes him to the vet, and the vet says it will cost $15,000 to fix the heart defect. So it's not impossible to fix the heart defect and transfer the puppy, but the purchase price of this puppy is only $1,000. So YDP elects not to have the surgery, and the puppy passes away. So while it's not strictly impossible for YDP to perform and deliver the puppy, it would have cost 15 times more than the contract price, which is so disproportionate a court would probably find it to be impractical in this case, and therefore the performance would probably be excused. Finally, in Step 12, we assess what damages are owed. In most cases of breach, courts will impose money damages. Money damages, in fact, expectation money damages, are the preferred remedy because they put the party in the position it would have been if the other had performed their obligations. We may also use reliance or restitution damages when expectation cannot be calculated with reasonable certainty. Sometimes the parties put in the contract in advance some liquidated damages, which are fine so long as they don't constitute a penalty. In extraordinary cases, courts will award what are called equitable remedies, which include specific performance, making the party complete the contract, a prohibitory injunction, prohibiting the party from taking some action in violation of the contract, and specific restitution, returning some unique, rare, or exceedingly valuable item that was meant to be transferred under the contract. So, finally, in illustration 12, Chandler here was harmed because he expected a puppy, and he got nothing. But he didn't pay anything either. So his reliance damages are zero because his position did not change, except he might be able to show an opportunity cost lost by not having the puppy for the period of time. However, he valued that puppy at a certain amount, and so the amount that he didn't get is his direct loss. I don't see any extra loss here. He avoided the cost of the $1,000, and there doesn't seem any loss avoided here. So the amount that he is expected is how much that puppy was worth to him versus minus the $1,000 it would have cost to him, and that's the amount the court will award to him in the case of a breach. Of course, a puppy is not generally considered to be so unique that a court will order specific performance, but if it was a very unique dog or a dog you had already owned, had a relationship with, that's the kind of item that might require specific performance. So in 12 easy steps, we understand how to interpret and determine whether or not parties performed under a contract. Now remember, this video only reviewed the basics of contract interpretation. We spent an entire semester studying all the details. Lots of additional statements in the restatement and in case law that we want to look at. But these analytical steps will give you some of the tools you need to understand the overview of how to perform for this semester. Thanks for watching. I hope you enjoyed this video and it gave you some tools that you needed to perform on your exams and to understand contract interpretation going forward. I'm Professor Seth Orenberg from Duquesne University School of Law, and a special shout out to Morty the Golden Doodle, my pet and friend who is glad to be a part of your video today. Best wishes and best of luck in your exams this year.